when I first started out as a patent attorney, they trained me on a dog bowl patent. And the reason why is that if you can get a dog bowl patented, you can get anything patented, right? So the storytelling in a dog bowl is super important. You need to kind of set up this dog bowl as a magical, super powerful thing that has, it has superpower. And the patent examiner is compelled to grant you this patent on this dog bowl. And so that's actually a very, very good way to differentiate the good inventors from the good patent attorneys from the bad one. That's because anybody can patent Einstein idea, right? But not so much anybody can patent a dog bowl idea. So in a storytelling, you need to kind of, it's going to depend on the technology. If the technology is already very complicated, I don't need to do much. I just simply say, oh, here's a need for this invention. And then I just go right into how it works. Now,
Mhm.
if I'm patenting a dog bowl invention, then I need to think twice very carefully and position it. Okay, I have to position the need for this. Why is this thing so critical that it's a must have? And then you need to put this dog bowl invention on a pedestal so that the patent office examiner look at it and they'll say, wow, this is the greatest thing since sliced bread. So for us, we tell a story differently depending on the technology. you know
So, well, and so that makes a ton of sense. But what I think is interesting is like you talk about this idea of needing to make it magical in some way, which I do think is very similar to more public facing pitching and storytelling. The basic structure that I look at is establish a situation, define a problem with that situation, and then introduce a solve or a solution or a product for that problem or set of problems. Is that at all mirror how you construct a patent argument?
well, yeah, we similar to your technique of a superhero, and then the superhero is facing some problem, and then you have a coach or a guide that would kind of lead the superhero toward his ultimate victory, let's say.
Right.
uh, we would normally set up what's the problem you're trying to solve, and then how did you do this, and then how does that allow the how does it help the world, basically. So that's a very common story that we do, and in selling it to the patent office. And you're not really just selling it to the patent office. That's just the first part. Second part after that is you got to sell it to your investors, right? That your invention has merit and has value. And then after that, let's say 5, 10 years down the road, when your invention became popular and now it's infringed by the big gigantic companies, that you're going to have to go and seek litigation to get money out of them. You have to convince the jury of your story and the judge. So it's really a long, long story. A long journey for that story, of which the patent office is the first, and then the VC, the venture investor story, is the next part. So I think that we can weave all of this into a consistent theme, and they're all really all aligned together. What you're trying to show is to put this new product, this new idea up on a pedestal so that an investor would pray to it and would shower it with millions of dollars.
How are you, I guess, it's the continuation of a story through those different stages of the funnel almost. But is an investor actually seeing the patent documentation that you have, or are you giving them a culled down version of the patent documentation? And then my follow up to that is, how are you looking at what should they know versus what do you want to play closer to the chest?
Yeah, I think that's a fine line you got to dance. Generally, I find the situation I encounter is the investor is going to ask, "Oh, how many patents do you have, and of which type? How many trademark do you have?" So take an inventory of your intellectual property assets. They rarely go down and look actually look at the content of the application. When you get down to that level, it tends to require an NDA, and also they tend to farm that out to a law firm who's going to review it and then generate a report back to them. And the law firm normally is going to try to ding it a little bit, just say, "Hey, I think this thing is obvious because of X, Y, and Z." But but if you can get it, that's a fantastic thing. So typically, that's what I see in the interaction between an investor, their lawyers, and a startup, and their IP lawyers, kind of corresponding. But generally, most lawyers do not really who's reviewing the patent. I rarely, encounter a situation where the lawyer review becomes an obstacle to funding. That situation is very rare.
You'll often hear a entrepreneur say our patent pending solution. At what point is it pending? Is it you've just filled out an app? Like, is that a convenient way to say we filled out an application, or does it actually mean it's under active review?
Okay, so when it's patent pending, meaning it has to be filed. Now, in the old days, it used to take months, maybe 30 days to 2 or 3 months between you as the inventor giving the document to your patent lawyer, and then they ultimately work on it and send you a draft. It used to take at least a month. Now, because of the advent of technology stacks, firms such as ours utilize the tech stack to expedite that, and we can reduce it down to weeks, and if needed be, we can do it in a day or two. And the so I tend to like very thick patent application. The
Mm-hmm.
idea is that the more details you think up front and you put into it, the more valuable that particular document is, because it's a document that's going to have to survive a 20-year journey during its life, from the time you file it to the time that it basically gets retired. That's a 20-year journey. So what you want to do is to pack that thing with as much food and energy as you can. And so we tend to write very long 50-page, 100-page patent application that we talk to the inventors, and we throw in every single variant. How could you do, how could you implement this particular technology in a different way than the way you've done it? How else could you use your invention? In what other fields could you use it? Um, and so we try to come at it at multiple angle, because you really got one shot. Once you put it in, that's it. The date is locked, and the content is also locked.
I heard a very interesting story yesterday that I don't know how much you follow basketball or historically have followed the NBA, but very legendary coach, Pat Riley. Um, in the early 80s, he was coaching the Lakers. And after they had won back to back championships, they had a good shot at winning three in a row. Now, apparently, the term three-peat is actually a trademark owned by Pat Riley.
Wow.
When he went into that season, he filed for a trademark on it and won it. But the Lakers never won the third championship in a row.
Ah.
Um, they, at least that team didn't. Later on, when Phil Jackson was coach in the late 90s, early 2000s, they did win three in a row. But the first team that actually did it in the NBA was the Bulls from 91 to 93. And apparently, and like their merchandise everywhere after the third title said three-peat. And then again, they won three more, and then there was three-peat again. But they had to pay Pat Riley a large sum of money each time that they were using the trademark. And then, in other sports too, when it happened, they're all paying Pat Riley. Apparently, he gives all the money to his foundation, which is nice. But it's interesting just to think that like something as simple as that is actually intellectual property that can be protected. And maybe it makes the case that anything you're doing that you think has like some kind of name equity to it is worth protecting.
Well, it's not. That's a great example there, Arash. But it's not just name. I mean, it can also be ideas, and so let me give you an example. About 20, maybe 23, 24 years ago, My mother has a stroke, and that's ultimately how I became a lawyer. Is that I went back from New York. I was like a management consultant, and then I went back to kind of take care of her. And so I had extra time, so I went to law school. So, but while I was doing that, because of my technical background, I also devised a little device that has a processor. It has an accelerometer, and you put it on the wrist to monitor, stroke victims who are moving with kind of a wobbly movement. So the first iteration of that, I was thinking, well, you know what, it's the Philips Life Alert. I've fallen and I can't get up. Kind of a smarter version of that. Traditional Philips device, you press a button when you need help, right? You have to manually press that button. So in
Yeah.
that particular thing, because of the stroke situation, the patient is very unstable. And in my mother's case, her right half was kind of disabled. She really couldn't move her right arm anymore. So even if she wanted to push a button, she couldn't do it. So then I came up with a device. It's a simple device, an accelerometer and a processor, an embedded low power processor, right? So it detects if there's a fault, then it would trigger an alarm message. So I patented that because at the time I was a patent law student. I patented that concept. I applied for it, and then I thought, this might be an interesting thing to see if we can get funding for. And I went to the venture capitalists back then in Houston. They were all interested in oil, and so nobody cared about electronic or software. So I said, okay, no investor interest. We'll just fold it up. But the patent lived on, right? And then about 4 or 5 years afterward, it dawned on me. I said, now wait a minute. That thing is a wearable device. It has a processor. It has an accelerometer. It has a wireless transmitter unit. Well, guess what is that mapped to? It sounds awfully similar to the smartwatch idea, isn't it? Back then, smartwatch wasn't a thing.
Sure.
We morphed it out to a smartwatch patent, and then ultimately we sold it back to Philips. And so Philip ultimately reacquired that, and then the technology then improved the I've fallen and I can't get up technology, and things like that. So that story tells you, if you carefully craft your idea and protect that, you never know what comes down the pipeline, how that technology might evolve into something greater than what you thought originally was the intent. The intent was an original wearable falling, and I thought a smart fall detection, but it ultimately is the genesis of smartwatch devices because that's the commonality in all of them.
So does that mean that you received compensation when these other companies came out and had, the Help I've Fallen, I Can't Get Up device and the smartwatch and all those things?
Well, I sold it to Philips, and so my gain was capped, but that was a good deal. We weren't
I mean,
unhappy
yeah, even if
about
it
it.
was a one-off, you're not getting like a royalty on it, but that's amazing.
Yeah, yeah. So that's a little personal story there.
So how do
But I
you?
think,
So let me ask you this then: how do you like? It's not like Philips is out telling the world they're going to do this until it's already in market. So you saw it was in market and you said, hey, hang on a second.
well, when I invented it, the Philips model was only a push button.
Okay.
If you fall down, you manually push a button that triggers an alert to help you. So and I was very interested in elder care technology because of my own mother's situation, right?
Okay.
So I went, I attended all of these. They call it the Silver Boom Wave conferences, where basically 15 years ago they were talking about how the elderly wave is going to be a boom, and that's going to drive a lot of services right into elderly service. So I went there, and then of course Philips, because of the product, they were there showing in a booth. And I went and I talked to one of the manager, and that person dismissed the concept completely. They never even saw it as an interesting product.
Mm.
Only later that through various connections we went and ultimately that somebody upchain of Philips saw the vision. But a lot of time when you have an idea and you go to a trade show and you knock on that companies, you're going to run into a lot of the not invented here syndrome. So
Yeah.
that's part of the challenge inventors have.